Hi everyone, my name is Evan Conroy. I'm an attorney at Conroy Law. This video is an introduction to bankruptcy law and how it affects community associations. First, let's go over what people typically mean when we say someone filed for bankruptcy. Bankruptcy laws are mostly federal laws that are intended to allow debts to be collected by having debtors' assets distributed among creditors while preserving a debtor's ability to have a fresh start. Essentially, bankruptcy law is intended to address two competing interests. One, creditors want to get paid, and two, debtors want a fresh start. The bankruptcy code is divided into chapters. This is why you will hear people say things like Chapter 7 or Chapter 13 bankruptcy. Chapter 7 and Chapter 13 bankruptcies are, in fact, by far the two most common types of bankruptcy filings that community associations have to deal with. Another far less common type of bankruptcy filing for community associations would be what's called a Chapter 11. A Chapter 7 bankruptcy case is likely what most people think of when they think bankruptcy. This case is a type of liquidation, and what that means is that all the debtor's assets that are not protected from liquidation are collected by the bankruptcy trustee, they're sold, and the proceeds from the sale are distributed to creditors that have filed a proof of claim. The reason some of the assets are protected from liquidation is to permit the debtor to have a fresh start after the bankruptcy case. Unfortunately, people that are eligible to file Chapter 7 bankruptcy cases don't have many assets, so in practice, typically, creditors don't get paid in a Chapter 7. At the end of the bankruptcy case, the court generally enters an order of discharge, which prevents creditors from seeking to collect the debts. Technically, there are certain types of debts that cannot be discharged, but community association assessments and related charges are not one of those types of protected debts. There is some good news for community associations having to deal with the Chapter 7 filer. First, many homeowners are not eligible for Chapter 7 because they are too well off. Also, a bankruptcy discharge does not include debt that arises after the discharge. Additionally, so long as there's a lien on the property prior to a bankruptcy case being initiated, generally a lien will survive, unaffected by a bankruptcy case, allowing the association to use its lien rights after the discharge. A Chapter 13 bankruptcy case is different. It involves a payment plan being monitored by the court and the bankruptcy trustee. The owner keeps all their assets and instead pays their disposable income to the trustee, and the trustee disperses the payments according to the terms of the Chapter 13 plan. The payments are not evenly distributed though. Secured creditors, those creditors with their debts encumbering the owner's property, get paid first and typically are paid in full. Unsecured creditors get paid whatever's left over, if anything. This is why it's so important to have a lien recorded before the owner files a bankruptcy petition. Now let's go over the folks that will be involved in the bankruptcy case. There's the debtor, which is the party that owes the money and is seeking a fresh start. There are the creditors that are owed the money. They can be further divided into secured and unsecured creditors. If you are a creditor, you definitely want to be treated as a secured creditor. Then there's the trustee, whose job it is to manage a debtor's estate during the bankruptcy proceeding, and then there's also the judge, who enters rulings that affect the bankruptcy proceeding, including whether it'll move forward or be dismissed. Before we go any further, let's discuss the three things that have the largest impact on community associations when discussing bankruptcy proceedings. They are the automatic stay, property of the bankruptcy estate, and the discharge. The automatic stay essentially bans all collections work for the pre-petition debt. This includes things like sending demand letters, filing liens, continuing litigation, scheduling a foreclosure sale, continuing garnishment work, turning off access to community property, as well as any other type of active collections work. It takes effect immediately when the bankruptcy petition is filed. It protects the property of the bankruptcy estate, and there are some ways that, however, that the court could be asked to lift the automatic stay if the debtor is not doing what they're supposed to be doing. However, the general rule is all collections work for the debt owed at the time the bankruptcy case was started is prohibited. Now, property of the estate. Property of the estate includes all the debtor's legal and equitable interest in property when the bankruptcy petition is filed. Anything that is property of the estate is going to be off limits for seeking to collect or exercise control over. For community associations, this means that both the debtor's money and the property in the community is essentially off limits during the bankruptcy case. A bankruptcy discharge is a court order that stops the debtor from being personally liable for debts. It's the primary reason why debtors start the bankruptcy process. They want the discharge so they are no longer personally responsible for those debts that were incurred at or before the time of the bankruptcy. This would include any assessments and other charges owed to the association when the owner filed their bankruptcy petition. Generally, it only affects personal liability and does not affect the association's lien and foreclosure rights. The court is typically going to grant a discharge at the end of the bankruptcy case. This is assuming that the debtor complies with bankruptcy law. If the debtor fails to do something they're supposed to, chances are the bankruptcy case will instead be dismissed without a discharge. This means that the association can still seek the debts owed at the time the bankruptcy petition had been filed by the owner. That pre-petition debt they can still go after, assuming there's a dismissal without a discharge. Now, what can a community association do to protect itself? First, if you're an HOA, it's incredibly important to record that lien. You need to record the lien prior to the case being initiated, and because of that, community associations, not knowing when a bankruptcy will be filed, should have in their collection policy that the lien would be filed near the beginning of the collections process. As we discussed before, liens are important because the creditor's claim will be given better treatment in a Chapter 13 bankruptcy case. The association's lien rights will typically not be discharged for assessments and related charges owed before the bankruptcy case was initiated. That's true for both Chapter 7 and Chapter 13 bankruptcy cases. There is, however, one exception regarding lien rights, and that is when a debtor involved in a Chapter 13 case moves to remove the secured status of a junior lien holder. They do it under using the authority provided in Section 506 of the Bankruptcy Code. Put another way, the debtor argues that there is more debt encumbering the property than what the property is actually worth. This is called lien stripping or 506 valuation. For community associations, this happens when the outstanding mortgage is greater than the market value of the property. If the debtor is successful, then the junior lien holder, in this case the association, would have its claim be treated as unsecured instead of secured. This reduces the chance that the association's claim will ultimately be paid. Lien stripping is a much bigger threat to community associations when the real estate market takes a downturn, and that was seen in the Great Recession from 2007. Thankfully, it is far less common in the 2020s when property values are often much greater than the purchase loan amounts. However, it's still a good idea for associations to actively monitor bankruptcy matters to watch out for things like lien stripping. Thank you for watching this video on bankruptcy laws and their effects on community associations. If you'd like to learn more about other community association topics, please check out our other educational videos. Thanks again, and I hope you have a great day.